Our first speaker, you want to start a couple minutes early? What? We're really lucky that Janine Hudson from DPS is here. She received a bachelor's degree from Texas A&M University, worked several years before earning her law degree from Southern SMU, and she started her legal career with the Texas Ethics Commission as an assistant general counsel, and then she's been at DPS for 6 years. She's runs her data, does everything at DPS. Managed crime records. So she knows everything there is to know about what sex offender, how the origins, and what sex offender registration is intended to, and the basics of it. And that's how we're going to start the day, by learning the basics. Thank you, Janine.
Thank you. Cut off low. All right. Good morning. Oh, come on. We can do better than that. I know it's early. Good morning. All right. That's a little better. Act like you want to be here. I know. Thanks for the introduction. As you said, I'm Janine Hudson. I am the managing attorney for the Crime Records Legal Support Section at DPS. So what that means is that I deal with sex offender registration. I also deal with expunctions, non-disclosures, juvenile sealings, anything to do with records, basically. We already kind of went through a brief, introduction of who y'all are. You've got criminal defense attorneys, we've got prosecutors. I'm neither one of those. So as the attorney for DPS, we are kind of a general agency that deals with sex offenders, but we are not prosecutors, we are not defense attorneys. We kind of sit in the neutral ground. I'm going to start off with, what role does DPS play? And this is really basic. So some of you who are familiar with sex offender registration, you may already know this stuff. I apologize if I'm speaking to the crowd, but hopefully the majority of you will maybe learn something. So DPS is the central repository of the information on the registry. We also determine if a person's duty has expired before we can remove someone from the registry. We make determinations on out-of-state offenses, and we also make a determination on comparing the Texas offenses to federal offenses. So are we cut off a little bit? See if we can fix that. Oh, there we go. That's better. Generally, there are about 20 people at DPS, that is the Sex Offender Registration Bureau. That mostly consists of field reps that go out and train the local agencies on how to input information. We also check the data, manage the website, that type of thing. There are only 2 attorneys right now that actually deal with sex offender registration at all at DPS. So we're a small group. So what does DPS not do? We don't register anyone. That is up to the local registration agency, the police department, the sheriff's office, TDCJ, community supervision department. Whoever is managing that person is the ones that are responsible. They meet the registrant, they submit all the information to the DPS website. We also don't prosecute anyone. That's up to the local prosecutors. We do not enforce city ordinances or probation conditions. That would be, the city police department, or the city prosecutor. That would be the probation department, community supervision department. We also don't approve deregistration or prevent a registrant from deregistering once their duty expires. That would be the community, or the Council on Sex Offender Treatment does the approvals, if you want to call it that, and they once someone's duty expires, we just take them off the registry. So, how does someone end up having to register? There are multiple ways, which I think, hang on, we skipped a slide. How do I go back? Yes, so the slides are all available, so you don't have to worry about
The materials
putting everything.
are in a Dropbox that we all got them into, and as more papers come in, they'll be uploaded to Dropbox at the end of the day. So you'll have everything. You'll have Scott Merchant and everyone, Matt Ferrari's art that was written article on the registration. That article should be in Dropbox now. So things are going to be available.
Yeah, mine includes all of the slides that I'm giving, as well as a couple of other sheets that just kind of condense the information a little bit better. So, okay, let's get this back to the main part. Sorry. Okay, so registration program in Texas began in 1991. This is the current Texas public sex offender website. I just included the link. Like I said, you'll have this available in your materials. The duty to register, there are multiple ways that a person can be required to register in Texas. I'm going to talk about each one of them briefly, but that's just kind of the overview. If you have a reportable conviction or adjudication, so Code of Criminal Procedure, Chapter 62 is all the sex offender registration information. A reportable conviction or adjudication is a conviction, deferred adjudication, or adjudication of delinquent conduct. It includes substantially similar out-of-state offenses. It includes attempt, conspiracy, or solicitation. It's all for the particular listed offenses. It disregards any pending appeals, and it also applies to all offenses occurring on or after 9/1 of 1970. So this is the list of reportable Texas offenses as of September 1st of 2018. Well, this is the first half of the list because it was a little big to fit on one slide. And as you'll see, some of them this includes specific Texas offenses under the Texas Penal Code. There is also provisions for attempt conspiracy of some of the listed offenses. When you look at this list, and the list that I give you in your handouts has all of these together on one page. The subsection is the letter that's beside each one. It's what subsection of 62001 or 62001 sub 5 that they come from. I rearranged the order because there's several of them, like the attempt or conspiracy says an attempt or conspiracy of A, B, G, and E. So I just kind of rearranged it so that it was an easy list that just from top down you can see it's all of these and it's conspiracies to commit all of those. And then it adds the new one. So if the order looks a little funny, that's why. So I'll go back here just a sec. One of the pieces of the reportable conviction is for an offense of another state, federal, foreign, or military offense containing elements that are substantially similar to the elements of any of the other offenses, but not a deferred adjudication. So what does substantially similar mean? That's one of the big pieces of what DPS does. We do substantially similar determinations. And what those determinations end up being is we look at an out-of-state offense and determine if it contains elements that are substantially similar to a Texas reportable offense. If an offense is substantially similar, then it's a reportable offense and it requires registration. An appeal, by statute, an appeal of our determination can be made to the district court in Travis County. Appeals do happen. They don't happen very often, and apparently they get randomly assigned to Travis County district courts. I've literally been at a hearing for one of these before, and the judge didn't know why we were there. So sometimes it takes a little education, which is hopefully part of why we're here. But they are in Travis County, they are in district court, but it's because that's what the statute says they have to be brought in. So note that there is no provision to waive registration pending an appeal. So if a person would have a duty to register until they successfully appeal the determination, because having the determination gives them a reportable offense. So there are pages and pages and pages of determinations that we've already done. There's a list for every state, all 50 states. There's a federal list, there's a military offense list, there's lists for a couple of different territories, there's lists for a couple of different countries that we've looked at. They're all people who have come to Texas with this offense, and we've reviewed it to see if it requires registration or not. These lists are published and they're accessible through the DPS secure website. So I say secure site. So there's a public site, which is the one that I gave you the link for before. There's also a secure site. The secure site is accessible to all of the agencies that do registration. It's the same information that's on the public site, except it allows them to go in and edit their registrants, make changes to what's on the registry. It also allows for some of the information that's required by statute to be input, but is specifically non-public information. Trying to think of an example, but there's some provisions for I can't think of it one off the top of my head, but there's a few pieces of information like non-public juvenile registrants that have been made non-public, so they are on the secure site because it's not public, therefore not on the public site. So other pre-existing determinations. So this is just a sample of this is the first page on every determination list that we do. Note at the top, it's got a date that it was published. So that's the last time that particular list was updated. Every list is only updated as we add new things or as things change. So there's not at this time, like I said, because there's so many different lists and so many different offenses, there's not a regular review of every offense, but it's as the law changes or as new offenses come in to be reviewed, then we'll add it to the list. So some lists, like California, is about 16 pages long and has been regularly reviewed and updated on at least a couple times a year probably. But some of them, like I think Maryland, is only about a page and a half, and I think it was probably last updated about 4 years ago because we just don't get those many offenses. So this is what the lists look like. It lists the out-of-state offense, and it's listed by the out-of-state statute. They're in number order, and it lists what the name of the out-of-state offense is, the offense date, and what the equivalent Texas offense is. And you'll see some of those about halfway down. It says not substantially similar. That means we reviewed that offense and determined that it would not require registration here in Texas. So if we've already looked at it, we'll go ahead and put it on the list so we don't have to go back and keep looking at it again. The offense date is really important just because the time of the commission of the offense is the relevant statute that we look at. So in a lot of cases, like if the California statute changed, so if you look at the like 266H for the pimping statute in California, well, from 1983 to 2004, it was pretty much the same. It was the same statute. Then they changed it in 2005. So it makes changes to what's equivalent because their statute's different. So it may match up or not match up anymore with something in Texas. So, so the comparison is the out-of-state statute at the time of the offense to the current Texas list of reportable offenses. And on occasion, you'll see on this list that something will just say, please contact the department. Usually that's a case where the out-of-state statute probably is substantially similar, but it may lump a bunch of things together, and we just really need to look at the specifics to see what it's equivalent to. Or part of it may be and part of it may not be. So I'm going to give you just a list of cases. I'm not going to talk about these very much, but in general, these are the main cases that guide our determinations. Garcia was the first one that really said, it's okay to look at the facts of the case because that was a case where the out-of-state offense was equivalent to our indecency with a child, but out-of-state, it included children up to age 18. Well, in Texas, obviously that statute is only under 17, so we were allowed to look at the facts and say, okay, what was the actual age of the victim to see if that would even be a crime in Texas or not. So Prudhomme expanded that a bit. This one is actually based on the substantially similar language of the penal code, not the Code of Criminal Procedure, because it uses the same language for like enhancement, using out-of-state statutes to enhance. It uses that same substantially similar language. So the Prudhomme three-prong test basically just gave a little bit more detail on what to look at, looking at the elements of the statute, and if they had to be similar but not exact, and what's the effect of those elements. And then the anonymous is kind of our biggest change to the case. It was a hybrid of Prudhomme and Garcia, but it combined those two approaches. And generally, if the elements of the statutes are clearly not substantially similar, then the offense is not reportable, and that's where the review ends. If the elements are more similar than not, but it's still not clear, at that point, then we can look at the facts of the particular case to help determine what Texas offense, if any, it's similar to. This new approach triggered a months-long project to revise all of the determination lists that were then existing in 2012. We actually have a person here that did most of that, Michelle. But other than that major change, there haven't been a lot of case law that have made big changes to determinations. Every once in a while, particularly under the penal code, we'll get a new case that specifically looks at a particular out-of-state statute, so we'll kind of roll that into our determination list because the court's already looked at it. But for the most part, just the analysis is how we make those determinations. So, the third way that a person can register is with an extra-jurisdictional offense. These are the sadly misunderstood stepchild of registration, but by definition, substantially similar offenses cannot be extra-jurisdictional. Instead, extra-jurisdictional includes federal, military, or foreign offenses that are not similar to any reportable Texas offense, but that would require registration under federal law. It does not include offenses from any other U.S. states. The definition of extra-jurisdictional says it can include other states if we have a reciprocity agreement with them, but we don't have reciprocity agreements with any of them. Question? Mm-hmm. So we get that question a lot, and it doesn't really matter what the other state does, because registration in Texas is not based on if you have to register in another state or not. It's based on the Texas rules. So we just take a fresh look at his original offense. How does that fit in with the Texas offenses? We do a substantial similarity comparison. If it's substantially similar, then he would have to register here. Yes. Sure. Okay, so it would under extra-jurisdictional, but if it's substantially similar, it cannot be extra-jurisdictional by definition, because if you look at the definition of extra-jurisdictional, it excludes offenses that are substantially similar. So we look at substantially similar first, then if it's not substantially similar, he wouldn't have to register here. You would then look at extra-jurisdictional. If it's federal or foreign, or military, we have, under federal law, then they would register whatever term they register under federal law. If it's another state, we don't currently have reciprocity agreements with any other state, with the exception, narrow exception being interstate compact agreements, which I'm going to get to in a minute. But mm-hmm. Right. Mm-hmm. Potentially, yes. Assuming that Ohio offense is substantially similar to a lifetime offense here in Texas. So, yeah. Mm-hmm. Oh, another question? Sorry. So if there is a federal offense, then they could be extra-jurisdictional in Texas. No, it's not. Like I said, I'll mention interstate compact in just a minute, but it wouldn't only be if it's a federal offense or a military offense or a foreign offense, really, because those all fall under the federal law. Right, exactly, and that's because under extra-jurisdictional definition, it lists federal, foreign, military, or other states with which we have a reciprocity agreement. So, okay. Any other questions? Yes. That's a good question, and I don't really have statistics. From the ones I see, I would say probably most of them get picked up on a traffic ticket and someone runs their criminal history and says, hey, you've got this offense, we think you need to register here. So they do, but I think her question was if they are in another state that no longer requires them to register, that state wouldn't be required to notify us if they come here. So there are, some that kind of get lost in the shuffle because of the way the states work together. Yes, sir. Okay, they are all on the secure site, or they're available if you just email us and ask. You don't have to do an Open Records Act request, first of all. You can call us, you can ask. We have a lot of people that just call and say, hey, I'm moving to Texas, do I need to register? And we will read it to them, we'll send them the list, we'll answer whatever questions they have. Part of the reason for that, we used to, but because the lists change on a regular basis, we had old lists that were out there that were no longer accurate. So in order to keep people from relying on a list that's no longer current, we put them behind the secure site because here's the other thing. A lot of people, when they come to Texas and think they might need to register, they'll go to their local sheriff or their local police department. All of those agencies can access those lists. So they can look them up and see and tell them, yes, you need to register, or no, you don't. Assuming they get it right, which we kind of have to rely on that anyway, because there's 700 agencies and there's 2 attorneys. So, yeah, people get it wrong. I don't doubt that. I mean, I've literally, sadly seen cases where, we had a case a couple years ago where someone appealed a determination. He'd been on the registry for 16 years. We realized we'd never done a determination because nobody had ever asked us to. It was, whatever local office he walked into in 1999 said, hey, that looks like a sex offense, I'm going to put you on the registry. So there's only, there's some things we can help, there's some things we can't. But yeah, assuming, which is why we're having classes like this, so more people understand how it works. But that's a lot of it, is just asking the question. Part of the issue, like I said, is like California, I mean, that list changes every 6 months. So it may or may not, and a lot of people, the reason behind the secure site and the reason to just contact us before you get a list is so we can explain, hey, this may not, this is current. If your offense isn't on the list, it doesn't mean you don't have to register. It just means we haven't looked at it before. So those kind of explanations kind of go with us giving you the list so that you understand a little bit more what you're actually looking at. So any other questions, comments? Okay. So the fourth way a person can register is if they're court or board ordered for a otherwise non-reportable offense. So again, this goes back to, we look at substantially similar first. We look, first of all, to see if they have a Texas offense that requires registration. If not, then the court or the probation or parole board might order them to register. This does include non-sex offenses. We currently have court or board ordered registrants on the registry for all sorts of offenses, including DWI, theft, arson. I pulled a list: enticing a child, failure to comply, possession of a controlled substance. Don't ask me. But apparently, when he went to court, somebody decided he needed to be on the registry. So the registration requirements in those cases must be written into the judgment or the supervision conditions. Keep them, and in those cases, I'll get into the length of duty to register in a minute, but in those cases, they generally only register, like if it's a probation condition, they register until they're off probation. So they would come off that when their probation discharges. Keep in mind, if the judgment states sex offender registration does not apply to this defendant, that means that it's not court ordered. But it doesn't exempt a defendant from any statutory requirement to register for that listed offense. There's no provision in the statute that allows a court to exempt an adult from registration unless they follow the deregistration requirements, which we're going to talk about more. Okay, the fifth way that a person can register is based on an interstate compact agreement for an out-of-state offense. This is kind of like a hybrid between the extra-jurisdictional and the board or court-ordered. but it's for out-of-state offenses. If the offense is substantially similar, then the person will register under that provision instead. But again, this is for offenses where it's not substantially similar, the other state requires them to register, and they're still on, like their probation is transferred to Texas. So and I am not a probation officer, but my understanding of the Interstate Compact Agreement is basically they register they are treated on probation here as if they were in their home state. So that means they have to follow all the rules they follow in their home state. The difference is here, unless the judgment, just like court or board order, specifically says they have to register for 10 years or they register until X date, then we have to go look back to the, say it's a Kansas offense, we have to go look back to the Kansas registration requirements and see. Well, I can tell you from reading a whole lot of other state requirements, most of their offenses, or most of their registration schemes say, if you move out of state, you no longer have to register. So at which point, it's not a requirement because they're now in Texas. So there are very few interstate compact registrations, but it's just more of a case-by-case basis on those. As we said, 50 different states, federal, territories, foreign countries, 50 different registration schemes. So they do not work and play well together. All right, so the length of duty to register. And I cite, like I said, you'll get a copy of the slides. I cite the statute that these come from in each one, so it'll help maybe explain well. The length of duty to register for Texas or substantially similar offense is either for life or 10 years after discharge for that offense. This is purely a statutory offense-based determination. It's not based on a risk level or any other standard. It's just based on the offense they were charged with. The length of duty for an extra-jurisdictional offense follows the federal SORNA requirement for registration, which assigns tiers based on the particular offense. There are also provisions under federal law to early terminate a federal registration, but that's up to a federal court to determine if a registrant meets those qualifications, and then their duty to register would expire at a shorter time frame. So if you meet certain requirements under federal law, you can get a court order that reduces I think it reduces lifetime to 25 years. It can reduce the 25 years to 15, and it can reduce the 15 to 10. So it just depends on if they qualify under federal law, and you'd have to ask a federal attorney that. All right. For court or board ordered or interstate compact, they are registering for the term set by the order. If there's no specific term listed, because some of them will just say they register for 5 years or they register for life on occasion. If there's no term listed, then they just register for when they discharge supervision. So once they're no longer on supervision, then they no longer have a duty to register and they would come off. So what offenses require lifetime registration? Well, here's a list. And again, this is something else I kind of condensed and put in your handout. Sexually violent offenses, which I've got a slide that shows you what all those are, and then these specifically enumerated offenses. I put obscenity at the bottom. This is one of those, the legislature, I ask so many questions and I don't understand. They list the penal code for obscenity, if it's obscene material visually depicting a child under 18, they list that in the statute for expiration of the duty to register, but it's not in the list of reportable offenses. So technically it's a lifetime offense, but nobody should really be registering because it's not a reportable offense to begin with. So that's, a little weird. These are the rest of the lifetime offenses. These particular ones, they are normally 10-year offenses, but they get enhanced to lifetime if the person has another reportable offense. So if a second reportable offense is there, then it gets bumped up to reportable. And that is only adult offenses, so if they have one juvenile one and then they get one as an adult, it does not make it lifetime because it doesn't include the adjudication of delinquent conduct. This is the list of sexually violent offenses. Like I said, this is a defined term, but it's included in the list of lifetime offenses. But under the definition, a sexually violent offense can only be committed by a person 17 years or older. So this wouldn't capture any of your juvenile offenders. Yeah, it does create a few inconsistencies because it makes, like for instance, because it's listed as sexually violent, it's a lifetime offense to register for burglary with intent to commit indecency with child by exposure, but it would be post-10 for actually committing indecency with child by exposure. So it creates a few like inconsistencies, but again, it goes back to a lot of the way the statute is written, like this last one, it's under 5A, B, C, or D. So they don't really kind of see that all those are not necessarily lifetime offenses themselves. All right, so then everything else is post-10 offenses. So I say post-10, that's 10 years after discharge, final discharge. So if they are incarcerated and then come out, then it's from that date. If they are only, basically get a fine, or the final judgment is time served, and then that would be the last thing that happened in that case. So the 10 years starts counting at that point. If they go on probation or parole, then it would be from when they discharge parole for that offense. We've had a few that add confusion because they got on parole for one offense and then went back to prison for another offense. That's not reportable. So a lot of those will just kind of calculate of when would their parole have ended, and then their 10 years would be calculated from that. So, and yeah, if you would note, aggravated kidnapping does show up on both lists. There are two different ways that aggravated kidnapping could be a reportable offense. One is with intent to violate or abuse the victim sexually, which is a lifetime offense. One is if the victim is under 17. So that one's post-10, unless they get a second one, then it becomes lifetime. So just to add less clarity. I don't write the statutes, I just have to deal with them. So case law regarding duty to register, just to kind of hit the highlights, Munja, the first one, discusses the enhancement from post-10 to lifetime when there's a second indecency with child by exposure offense. It does talk about, because the language of the enhancement is if before or after there's another offense, and it talks about that before or after can include like two different convictions on the same day. So it is an unpublished opinion, but we don't have anything else to go by, and the reasoning makes sense. So that is constrained by Harris v. State, which explains that multiple counts indictments should not exist for indecency with child by exposure when only one event of exposure occurred. So out of fairness and consistency, if there's only one exposure event, even if you have two separate convictions, we would only make that person register as if it was one. So
the person exposes themselves to 10 children at the same time
should only be one offense.
Still one.
That's what Harris v. State says.
And if they get multiple convictions, still have one event.
Yeah, and in fact, Harris v. State, that was what happened. Is it was one exposure, multiple victims, but they basically said that the victim isn't an element of the offense, so there should only have been one conviction. In fact, I think they basically just tossed two of the counts and left the one. So I don't remember exactly how. Yeah, exactly. Yeah, exactly. So that's the thing is, so we'll look at those and see, and like I said, for consistency's sake and just out of fairness, we would only make that be a 10-year registration. Sometimes though, when we're looking at it, we really need, in a lot of cases, we may need the offense report, something to be able to tell, because multiple indictments that may say the same date of offense may or may not actually be a single exposure event. So a lot of times we'll pull the offense report. We've had cases where it's as narrow as he flashed one child over here and turned around and flashed a child over here. I'm like, well, it's only two separate exposures, so two offenses. Yes, question? We're not the fact finder. Usually, 9 times out of 10, we'll use the indictment. Because if the indictment says two different dates, then obviously it's two different incidents. Or a lot of times just the report will also go, it kind of depends on what we can find, what information we have. The offense report is one. We'll also use, sometimes, if it's a recent case, we'll call the prosecutor or the defense attorney and say, can you help us figure out what happened? Because most people, I would say probably everybody in this room, doesn't want anyone to register any longer than they have to. So we're trying to figure out the right information and find the right way to do it. Usually it just informs the opinion. So usually if there's a dispute, I mean, a lot of times I don't think it's ever come down to that where there's been that kind of a question. 9 times out of 10 it ends up being that it's clear from the indictment, or there's maybe a plea, I pled to doing this to victim 1 and doing this to victim 2 at a different time. So it may just be whatever we've got to go by. Yes? I am familiar with that case, although I would dispute a little bit what the actual finding was. It said in that case that the indictment was not an affirmative finding. So what the language is for the particular offense there was unlawful restraint. The question was if the victim was under 17, and the requirement in the statute is that there has to be an affirmative finding that the victim's under 17. And the language in the statute says either the order has an affirmative finding or the papers in the case an affirmative finding that the victim's under 17. And basically the finding in that case was that the indictment itself is not enough to be an affirmative finding because it's a charging instrument, which, yeah. No, because for the enhancement purposes under indecency with a child, it just requires 2 separate offenses. It doesn't have the affirmative finding language in there that there be an affirmative finding of an age, like that particular offense does. So, any other questions? Yes. So, juvenile offender is juveniles are always post 10. So it's 10 years from the date of discharge. Now there are, which I'll get into in a minute, there are other provisions for waiving or deferring juvenile offenses, but in general it's 10 years after discharge. So it depends on what the discharge date is. A lot of times they'll, like if they're in TCDLA, a lot of times they'll discharge on their 18th birthday. So that may be the start of their 10-year, term on the registry. So it really just depends on when they discharge. Yeah, I'll get to those in just a second, actually. So I'll cover that. Basically, I'm going to talk briefly about registration itself, and then I'll get into removals. So, where and when does a person register? Basically, they go to their local registration agency. It's usually the sheriff's office or the police department where they reside. There's an initial registration, and then verification is at least annually after that. If they have 2 or more sexually violent offenses, they have a 90-day verification requirement. If they are civilly committed, they have a 30-day registration requirements. The plus or minus on those, the annual registration is based on their birthday, and they have basically the month before or the month after to come in. If they are a 90-day, a quarterly registrant, then they get kind of 15-day window on either side of that 90th day. And if they're 30-day registrant, then it's a 5-day window on either side. So there are a few things that require in-person reporting. So 7th day before or after the move. If they're homeless, they have to report in person every 30 days so that the agency knows where they are. And then there's certain information that only requires reporting at verification. They just do that the next time they come in. So the other requirement for registration, when a person is on the registry for their initial registration, their driver's license, they get a nice little letter from our driver's license division that says your driver's license is going to expire in 30 days. Yes, I know you just renewed it, last week and it was good for 6 years. Sorry, you're on the registry. It expires in 30 days. You have to come in then annually after that to renew it. And that's again set by statute. They've made a couple of tweaks to that in the last couple sessions, mostly regarding the civilly committed registrants who are in the center. Yeah, basically, so that they don't have to go back every year to renew, because as long as they're still in the center, they know where they are, so they don't have to update their driver's license. Like I said, there's a few offenses that require 7-day reporting. And that's within 7 days of the change. There are a few that require 10-day requirements or 10-day reporting, and then there's, you know, basically everything else is just at their next regular verification. So like if they go out and buy a car the day after they come in and do their registration, they don't have to report it until their next annual verification. So how does someone get off the registry? Because I think that's why we're all here, right? So the expiration of the duty to register. So if the duty has expired, then we receive a removal request. And we can get a removal request from the local registration agency, we can get it from the court that has jurisdiction, we can get it from the registrant or their representative. There is no automatic renewal or removal once the duty has expired. We have to be notified because, quite frankly, there are 94,000 people on the registry, and what it is there's an automatic notice that goes out to every agency that has that individual assigned to them. So basically the last agency they registered at, they get regular like monthly updates of, you know, somebody whose verification is due or somebody that, you know, needs to be removed or whatever. They get those notifications, and then it's up to those 700 plus reporting agencies to notify us if someone needs to be taken off. So by statute, we are required to determine that a person's duty to register has expired before we can remove them. So it's really helpful if you're, say, sending in a deregistration order to put the reason for deregistration in the order. I can't tell you how many orders we get that just say motion for deregistration granted. Okay, I gotta go find the motion, I gotta go figure out why they qualify, and we've got to, you know, basically be able to fill in all the boxes in order to take them off. If you want to help expedite it, say they're being removed because they're a juvenile and the court waived their registration. Or whatever, you know, cite whatever statute it is that applies that is allowing them to be removed. That helps speed up the process a lot. The duty to register does not expire if a person moves out of the state or out of the country. It does not expire if the court believes they're rehabilitated. That doesn't entitle them to be removed. It also doesn't expire if their deferred registration is complete, because that in and of itself doesn't change their duty to register. They still, in fact, that triggers usually the post-10 registration if they start after discharge. Their duty to expire also doesn't expire even if their conviction is being appealed. So they will no longer have to come in and verify if they've notified us that they're moving out of the state or out of the country. They don't have that annual or 90-day requirement anymore, but they're still on the Texas registry until they expire. So a lot of times you'll see people that are on the registry and like their ending registration date passed. Well, it may be because they haven't been checking in with anybody, so nobody notified us that they needed to be removed. It also may be that they moved out of state or out of country and don't even realize they're still on the registry. But technically, I mean, a lifetime duty is a lifetime duty, and until something changes to, make that duty expire, they're still on the registry. Now we've had comments, complaints, questions in the past because people moved and then they come back and then they move again. And well, the last time I moved, I wasn't on the registry and now I am again. Well, that didn't really change. Thank you, internet. Because really what happened is the information is a lot more available. So there's a lot of countries now that 10 years ago weren't checking to see if someone was on a registry because they just didn't review them. Well, now all of that information is out there because public information and the World Wide Web, and it's easily accessible. So we've had, sad cases where someone has moved out of the country, comes back, and then can't move back to the country they've been living in for the last, I don't know how many years, because that country now says, oh, you're on the registry, I'm not gonna let you in. Unfortunately, we can't control what those countries' requirements are, and it's up to them. Yes, sir. That's true. I think they just started that last October or so. Yeah. Yeah, there's a few that just won't let them in the, we've literally had, I've heard stories, because I don't know personally, but I've heard stories of registrants who go, book the family vacation, fly to the other country and get turned around at the border and say, nope, we're putting you on a plane back home because you can't come in. So yeah, I mean, that's the thing, is a lot of it is just more widespread now, and more people in other countries are more aware and have set their own rules where maybe they didn't have rules before. So so juvenile, you'd asked about juveniles. Juveniles can file a motion or waiver for deferral in the juvenile court. This includes juveniles with an out-of-state offense. The court can waive their registration, defer registration, or make it non-public. If they have an out-of-state offense, obviously they didn't have a juvenile court here. What the statute says is they can go to the juvenile court in their county of residence. So if registration is deferred, then once the juvenile successfully completes treatment, they automatically earn their waiver, unless a hearing is held on the motion of the prosecutor and the court determines that the interest of the public would require registration. So 9 times out of 10, juvenile gets deferred, successfully completes treatment, he gets a waiver. Note that the record of successful treatment is sometimes the only indication that registration has been waived. And because it is possible to seal a juvenile record but them still be required to register, the juvenile sealing statute exempts Chapter 62 records, which is sex offender registration, from juvenile sealing orders. The problem is it doesn't allow DPS to view those sealed records. So we get a sealing order, we've got the person on the registry, and we can't tell that they need to come off. Or we can't tell that they don't need to be on, and they were just never put on in the first place. Unfortunately, we can't get those records. So a lot of times, defense attorneys, if you get that call back from someone in my office saying, hey, can you go get us this guy's deferred order or the order that waives his registration? It's because we probably don't want to put him on, but we can't tell he doesn't need to be on. So that's where some of these things don't always work and play well together. It's important to notify, that's also why it's important to notify DPS if a deferral or a waiver has been granted. And if a deferral gets granted, keep track and send us the paperwork showing that he successfully completed treatment and the waivers, and now has been able to waive. Because again, a lot of times once that record gets sealed, and with the automatic sealings, a lot more of those records are getting sealed, we can't tell. So we really hate to put it back, 10 years down the road when someone picks the guy up and runs him. We hate for him to be on the registry if he didn't have to. Yes, sir. Question. No. Okay, Scott. So there is a provision in the statute that says if they are transferred under the, I forget what section of the family code it is. Yeah, that one. If they're transferred under the family code to an adult court, they are still a post-10 registrant. So they get transferred, but they're under 17 at the time of the offense. They would still only have a 10-year duty to register. Pretty much every juvenile across the board, if they committed the offense when they were under 17, will only ever have a 10-year duty to register. Yes, ma'am. Mm-hmm. So I believe, and this is one of those where the legislature kind of made a few weird adjustments, when they added the requirement for offenses, or for trafficking offenses to report the vehicle, they made that a 7-day requirement. So if it's a trafficking offense, I believe that one does have a 7-day reporting requirement. But if for any other offense that they're just on the registry for, it doesn't have to be updated. Now, I will toss that in with the caveat, I can't guarantee there's not a local registration agency telling you how many needs to submit it. It's in the statute, basically, if you review it, or I'll give you, at the end of it, I've got the contact information for the Bureau, and they can review that person individually and figure out what's going on. So, yes, Scott. Actually, 254 counties in Texas. There are 732 different agencies at last count. So what the 20 people that I told you about, that's our Sex Offender Registration Bureau, 6 of them are what we call field reps, and they go out and do training on how to input stuff in the website. Here's the changes in the law. We also do every 2 years, so after session, it'll be November, I think it's November 11th through 14th this year. DPS puts on a conference for all of the registering agencies to both train new people, because, I mean, just like any other agency, they have turnover and they lose, institutional knowledge, or new people come in who've never done this before. So we do training for them. We also do training on new offenses that have become reportable because of legislative changes, or any other legislative changes that have happened that, so that's why we do it every 2 years, because it's after every session, to add in that information and to make that available to the people that are actually doing the registration. I don't know how much internal training those agencies do. It probably depends on the size of them. But just to give you a little perspective, I mean, there are some of those registration agencies that are large, like San Antonio Police Department. They're large. They have multiple locations that do registration, and they have multiple officers or individuals that are familiar with registration and that do the actual registration people. But there's some agencies that are small and maybe have one guy who registers the people in his county, one day of the week, and he may or may not have been doing it for 20 years. But so there's a lot of variation in what's out there and what's available. We are always available to answer questions. Like I said, we're kind of sitting in a unique position because we don't prosecute cases, we don't defend cases. I've never charged anybody with failure to register, but we see thousands of these cases every month. So we try to help as much as we can to make information available. If nothing else, we can say, well, I don't know that particular case, but I know this county had a similar one. Let me put you in touch with the registration agency in that county and see how they handled it. Or let me put prosecutors in touch with each other and say, I know this county has done that before, so let me put you all two together. Same with defense attorneys. I've talked to defense attorney that handled a similar type of case. Let me put you in touch with them and see what happened with that one. But there's a lot of the issues like that where it's just we're trying to share information as much as we can. So and like I said, with 700 plus different agencies, plus how many judges and how many defense attorneys and everyone else, there's a lot of people to try to get on the same page. So any other questions? All right, let me have a. So I know that deregistration is going to be covered in more detail the rest of today, but just wanted to touch base on this. That is one way that people can come off the registry. It is available to adults offenders. It is available to Texas adult offenders. The reason it is not available to out-of-state adults is because there's no provision in the statute, and it requires them to go back to the court that convicted them. So out-of-state, it can't grant a Texas deregistration, so out-of-state registrants are kind of out of luck. Out-of-state juveniles have a special provision that allows them to deregister here. So we prepare a list of eligible offenses. There's a new rule that was just adopted. It became final on March 14th. It's on the public site. There's a link if you scroll down under additional resources. You can get to the rule. This is the direct link to the rule, but I figured the other one was easier to remember, so I put both. The rule lays out the Texas offenses in their equivalent federal tiers, and it's verified by the DOJ's SMART office, which is the Sex Offender. God, I'm not gonna remember it. Sex Offender Sentencing Management, Adjudication, Registration, and Tracking. That one. Thank you. So, which the statute requires us to have DOJ review it periodically. In this particular case, like I said, I know that it's going to be covered in more depth, but just a quick touch on deregistration. If the Texas registration for that offense is longer than federal registration would be for that offense, then they're eligible to apply for deregistration. Person must have a single reportable offense, so it has to be only one. They get an evaluation by the Council on Sex Offender Treatment. There's an individual risk assessment and motion filed in the original criminal court. The prosecutor can object if they're not entitled to deregister. If the order is granted, they should present the order to the registration agency to submit a request for removal. Again, I can't tell you how many of these get granted and we see them like 4 years later. because nobody ever told us. So the guy thinks he's earned his waiver or has earned his deregistration, and probably has, and nobody notifies DPS, so he doesn't actually come off. There is a removal request that the local agencies fill out, and it gives us all of the information we need to take that person off. And it's everything from running their criminal history to giving us the order to explaining what the order's granting. So going back to the registration agency is probably the easiest way to make sure a client comes off as quickly as possible. Yes.
You say here that prosecutors can object if not entitled to
Deregister. Yes.
They have
a single reportable offense. They do have to set it for a hearing. There has to be a hearing. So.
But the only objection is they're not entitled to it, or.
Well, I mean, I suppose they could. So technically, I guess you're correct. They could object for other reasons, because it is a discretionary thing on the part for the judge. So it's up to their discretion if they deregister or not once they've met all the requirements. Yes, sir. Okay, so that's true. I should have been a little more explicit. They're required to hold a hearing before they can deregister, before they can grant the deregistration, is what the statute said. If they choose to just deny it outright, they don't ever have to hold a hearing. Again, it's discretionary, so they could do that. But yes. Mm-hmm. We haven't done assessments. Part of that is because I can't tell you how many were eligible under the old chart. Partly because when we remove someone from the registry, like I said, goes back to we don't always know that they were deregistered to be removed. So I don't have numbers on how many people get deregistered to begin with. Okay. Unfortunately, it's hard to tell. Part of the reason why is because there are offenses like that where maybe less people are eligible to deregister, but there's other offenses like indecency with a child where more people are eligible to deregister now, whereas it had other provisions before that they couldn't. So what I can tell you, I know other people are talking about the chart in more detail, so I'm not sure how much you want me to cover now. But like I said, the requirement in the statute is that DPS make the list of offenses under the federal requirement. So remember how I talked about Texas has lifetime and post 10, federal has tier 1, tier 2, and tier 3. So basically what was required is to take the list of Texas offenses and put them into the proper tier for where they would be. Well, Texas had a formal SORNA review by the Department of Justice 2 summers ago. So in October of 2017, we got a response from DOJ. This is going to get a lot more technical. I'm not sure how many of y'all really want all the details. But Texas is not a SORNA compliant state, which sounds kind of weird until you realize that there's only like 12 states that are SORNA compliant. And what that really means is that all of the statutes that we require registration for and the registration scheme that we have as far as how long they register, how often they report and everything, doesn't exactly match the federal scheme. Which again, 50 different states, 50 different schemes, kind of makes sense. But everyone, we did our first formal SORNA review. So what happens is we can submit a packet, and it's like this long, and it took months to put together, to the Department of Justice, the SMART organization, and they will review all of the different aspects of the Texas statutory scheme and Texas registration scheme and determine if we are compliant or not. Well, big shocker, they determined we're not compliant. I can tell you that the majority of ways we're not compliant is because we require registration for some offenses that the feds don't, and vice versa. Which, quite honestly, those are going to be legislative changes that nobody else can do unless the legislature gets on board with it. So we will probably never be some sort of compliant, at least not in my lifetime. But in that review, one of the things that they did is they gave us a list of all of the then current Texas offenses under these federal tiers. So we looked at it and said, you know what? So I will run the caveat of I wasn't here then, but when that first statute was created that said DPS needs to review these and rank these, it says that DPS shall do it by rule. Well, no rule was ever made. I don't know why. There was a lot of changeover. Who knows? Ball got dropped. No rule was ever made. We had a list that got put together, but the rule was never done. So we took it back and said, okay, well, we've got this list from DOJ. Let's look at the list and let's make a rule and follow what the statute says we should have done in the first place. So we put together the rule and basically drafted. And if you look at the rule, which it's actually in the handouts that are on your Dropbox link, I included the rule itself and the chart and everything else. But the chart that goes with the rule is exactly the DOJ list that they gave to us when they reviewed it and said, these are where we place your Texas offenses. The only differences are compelling prostitution and bestiality, which were two new offenses, continuous trafficking and bestiality, which were two new offenses that were added last session 2 years ago, which was after we'd submitted the report to DOJ. So all I did was plug those two in the appropriate places, and there's our list of offenses. So that's what the rule is that we have to tier those offenses. And then we compile a list from that after we've tiered the offenses that it's literally plug and play. We took the Texas offense that's now tier 1, tier 2, or tier 3. We looked at what the real registration period is for that Texas offense, lifetime or post-10. If it's longer than the federal offense, then they can deregister. If it's equal to or shorter than the federal offense, they can't deregister. So that's really where the new tier list came from. It's that rule making plugged in to match them up. And I did it nice and pretty, so it's red and green. So if it's green, they can deregister, and if it's red, they can't. So try to be as simple as possible. Yes, sir. But so the way that the statute is worded, we can get a removal request from a court, but DPS is required to confirm that the duty has expired before we can take them off the list. So in that case, we look at it and see, and if they met the requirements. Now there's a few adjustments to that, just because under the deregistration process, there is a provision where the court that's holding the hearing can determine that it's not equivalent, it doesn't have the same federal registration requirements that we determined it did. So if the court rules that, then obviously we'd follow that. But if the court just says, well, I don't care what they say, yes, it's longer, but I'm gonna make him deregister anyway, well, he doesn't have any statutory authority to do so. So, yeah. And that's what my department spends most of its time on, is opposing those or appealing them. So it happens a lot. I mean, it really depends. If we find out about it early enough, we've appealed a few of those to just say, hey, look, you don't have jurisdiction to do it, or we'll file. I mean, I don't think we've done it because it comes up so rarely. Potentially we could do a bill of review to say the court didn't even have jurisdiction to grant this. So there's some of those provisions there. A lot of times, though, you're right. I mean, especially we get them 4 or 5 years after it's been signed. We just take them off. I mean, it's at some point there's nothing we can do other than follow the order that we've got. So, yes. Yeah, that's the threshold that the legislature has set for it. They have to be registering longer in Texas than they would under federal law. And now, on the flip side of that, if they are registering like Texas has a lifetime offense, under federal law it's 25 years, they are registering for a shorter amount of time under federal law, so they would be eligible to deregister. There is nothing in the statute that says they have to wait 25 years before they can apply for deregistration. So as soon as they qualify to deregister, again, federal requirement is 25 years, Texas requirement is lifetime. Federal is shorter, so they can apply to deregister. There is nothing in the statute that says they have to wait 25 years before they can apply. Now, I'll be honest, it's discretionary on the part of the judge. If he knows that under federal law this guy should be registering for 25 years, I've seen judges or heard of judges that have sent him back and say, come back to me in 25 years. I'll talk to you then. But it's purely discretionary on the part of the judge at that point because they qualify to apply for deregistration. Again, assuming they meet all the other requirements, it's a single offense, they've gone through the Council on Sex Offender Treatment, gotten their assessment and all that stuff. Yes, sir. Mm. Right. Yeah, like I said, that's that exactly, and that's the provision set by. Okay, I'm getting signals. I've got to wrap it up. So I'm going to go through these real quick. Just a couple of points that cause frequent confusion. The offense determines the term. The length of duty and the verification frequency are not impacted by a risk assessment or anything else. They're all dependent on the number and type of offense that the person has. So if he's got 2 offenses, they're both sexually violent, he has to show up every 90 days, no matter what. Even if he's got a low risk assessment or no risk assessment. The waivers, although a court may order registration except in specified circumstances for juveniles or, yeah, I think I wrote that wrong. Okay. May order registration, except in specified circumstances for juveniles or young adults, a court may not waive the statutorily required registration. So they can order somebody to register for a non-sex offense, but there's no provision in the statute that allows them to, not require registration unless they meet the other requirements to deregister or to be eligible for a waiver. Indecent exposure. The second violation of indecent exposure must result in a conviction, not deferred, to be reportable unless the deferred is revoked and adjudicated. Because what the statute says is it resulted in a final conviction. So if it was a deferred adjudication, it requires 2 offenses to register for indecent exposure. So if the first one's a conviction and the second one's deferred, he doesn't have to register. If they're both deferred, he doesn't have to register. If they're both convictions, he does. If this one's a conviction, the second, third, fourth, fifth, and sixth one are deferred, and the 7th one's a conviction, then he'll have to register. So because it says the second offense, but not if it results in a deferred. So it's a little weird. We get questions all the time. Juvenile offenses are always post-10 unless they're waived or deferred under subchapter H. Juvenile includes anyone under 17 at the time of the offense, regardless of whether they were certified as an adult or not. The question you had earlier. Out-of-state deferred adjudication is not reportable, regardless of whether it is substantially similar to a Texas reportable offense. Part of that is because states call things different things all the time. So what they call deferred may not really be deferred. I can tell you what they call expunctions is not usually an expunction. But if they got an out-of-state deferred, it does not count as a reportable offense because in the definition of reportable offense for substantially similar out-of-state offenses, it has to be a conviction. So just a few statistics, if you like numbers, which I went to law school, I don't do math. But there are 94,000 active registrants on the Texas registry right now. 16,000 of those have addresses that are outside of Texas. So they've been reported to us as out of state or out of country. 11,000 of those are listed as incarcerated. Your duty to register does not expire when you go back to jail. You just don't have to verify anymore because we know where you are. So, 1,700 are listed as absconded. 440 are listed on the registry as deceased. What that usually means is somebody reported them to us as deceased, but we haven't gotten some kind of proof of death certificate, postmortem prints, or anything else. We used to take those off automatically when it got reported to us, but we had too many of them show up alive, so we stopped doing that. Go figure. But this is my contact information. Like I said, all this information, the slides are in the materials you will receive. I am more than happy to answer questions. The number I've given you and the email go to our Sex Offender Registration Bureau. There's 20 people there. They can answer a lot more questions than I can. If it is something that you really need my input on, please feel free to put my name or ask for me. They'll transfer you. So that's all I've got.
Our next speaker is Scott Merchant. Scott graduated from Washington Lee University Law School. He was in private practice. Then he was Janine's predecessor with DPS, and is now working for the Health and Human Services Department of the state of Texas, and he's assigned to represent the Council on Sex Offender Treatment. And he's the person that, when you apply for deregistration, does the certification that you're eligible for to apply. So he knows more about deregistration probably than most of us, or anybody. Wow. Yeah. Here's the clicker.
Thank you, sir. Good morning. I would say mediocre morning, but probably would know how to react to that. So a little bit of history. Sex offender registration has been around for a very long time. Anyone want to take a guess at who was the very first state to actually create a sex offender registry? No, it was California. Sorry, I'm a little bit taller. Anybody want to take a guess at when this was created? 1947. It has been a really long time. Texas started their registry in 1991. Obviously, it has changed a lot over the years since then. It used to be that it was only prospective. It was not retrospective. Obviously, now anyone who has a reportable conviction on or after September 1st of 1970 does have to report. The feds eventually got involved in registration themselves. The first time was the Jacob Wetterling Act of 1994. With that, it required a 10-year post-discharge and lifetime registration. Now, you will notice that this looks an awful lot like what we have right now. What they did is, how the feds did this and how they got us to comply is the fact that they tied purse strings to it. Because obviously, the feds can't make us do anything. Well, they can when they give us a gigantic pot of money. And at this point in time, when Jacob Wetterling was passed, it was a gigantic pot of money. That 10% loss about 10 years later, because a lot of this I'm having to rely on my memory because I have not been able to find statistics of exactly what the state of Texas had available to it from 25 years ago, which that's depressing. So a lot of this is memory because I was involved in a lot of these things when they were going on. Texas actually did obviously reach substantial compliance. Then the Adam Walsh Act was passed in 2006. That means the 2007 legislative session was the first time that Texas addressed whether or not they were going to become Adam Walsh compliant. Adam Walsh tiered, very different from the Jacob Wetterling Act. The key to this is the burn grant funding almost completely evaporated. I don't know if anybody remembers what the economy was like back in this time period, but it wasn't the greatest. In 2005, 4 or 5 time period, you were talking about losing tens of millions of dollars. That's how much Texas was going to lose if they did not comply with Adam Walsh. However, when the 2007 session started and they were looking at what was going to be happening, that funding, suddenly that 10% of the burn grant funding was about $1 million. There's a big difference between $1 million and about $30 million. The costs were run for what it was going to take, and obviously this is my opinion. I cannot verify that this is what the legislature was thinking, but it seems perfectly logical that if it's going to cost us over $1 million to comply and we're only going to get $1 million back, it's not worth it. And that is one of the reasons why what Janine said earlier about the fact that Texas is probably never going to comply until we get a gigantic pot of money again, it probably isn't going to happen. The subchapter I, the sex offender deregistration, was added in 2005. And everybody's life has been exciting since. So the reason I did not list 401, even though that is the start of the statute, that's just a definition, and it defines what the Council on Sex Offender Treatment is. 62.402, DPS has the duty to determine the length of duty for registration for under federal law for each reportable offense. Back prior to, it was 2011 when the statute changed, it actually was up to the council. The council never did it. I cannot tell you why. I was not with the council at that time, but it was 2011, DPS got the duty, and they eventually started making that list. I have an arrow.
Okay. All right.
One of the things is juveniles. It's already been addressed. Juveniles have a post-10-year duty of registration. Therefore, because you have to register longer under state law than under federal law, and the minimum duty under federal law is 15 years, unless the juvenile has no duty whatsoever to register, subchapter I does not apply. The reason I'm even addressing juveniles with subchapter I is I've had multiple attorneys, not just lay people, but I've had multiple attorneys actually petition under subchapter I to have their juvenile deregistered. There's other avenues with juveniles that I would recommend. They're much easier, much faster, much cheaper in reality. And the chances of getting to deregister under subchapter I, at least as a juvenile, are very slim. So the next step is the council has to create an individual risk assessment. They have to develop a risk assessment tool. I am not going to address that at all because that is way outside of my expertise. That will be addressed later today. One of the things that they have to look at is the criminal history of the offender, and that's supposed to be an of, not an in. That you have to look at both the state and the federal criminal history. I have convinced almost every single person I have ever worked with, and I am slowly but surely convincing the council as well, we have to rely on fingerprint data because that is the only way for us to know this is the specific individual that we are dealing with. There have been too many times where it's a common name and we have the wrong person. And that causes enormous problems. How can you accurately diagnose someone and look at their criminal history if you're not even looking at the right person? Fingerprints, as all of the problems that criminal history has, just by its very nature, garbage in is garbage out, they at least have the fingerprints right. The fingerprints, they're yours. And I think in the entire history of the world where they have been developing fingerprints, they have found 2 prints that have matched from different people. Not sets of prints, a single print. Think of all the millions and millions and millions of prints that they have come across. They actually have found one. So that also tells you there are probably 2 snowflakes that are the same as well. With that individual risk assessment, it is seeking to predict the likelihood the offender will engage in criminal activity that may result in the offender receiving another reportable conviction. In other words, they're going to offend again. We do not care whether they're going to burglarize a car. We don't care if, well, I'm not going to say we don't care, but for the purposes of deregistration, it does not matter. It can be jaywalking, don't care. Murder, in reality, we don't care. It does not matter for the purposes of deregistration, because that is not what the statute says. Rather, the statute says, are they going to reoffend as a sex offender? Also, are they going to be continuing danger posed to the community? On written request of an offender with a single reportable conviction of an offense, that is when the council will start looking at the individual. If they have multiple convictions, we will not look at them. Additionally, we also will not look at them unless it is on the list that DPS has generated. Oop. So once they have the offender has gone through all of that, the risk assessment is performed and a written evaluation is produced. Now, it is not the council themselves who actually produces this evaluation. They have farmed that out to individuals that they call deregistration specialists. These are, I do believe, most of them are psychologists, a couple of them are counselors. I think there's a social worker as well, because the council, to be a member of the Council on Sex Offender Treatment, to be licensed by them, I should say, you have to have an underlying mental health license. But most of them are psychologists. Dr. Ferrara is here. He is a psychologist, a licensed psychologist, I should say. And they will produce that assessment. That assessment comes to me eventually. So assuming that everything has been compliant, we'll get to the specifics of exactly how this works. They have to file a motion for early termination. In this motion, it must have the certified copy of the assessment and an explanation of why this offense is eligible for deregistration. Now, I can tell you I have seen I've seen several of the petitions, I've seen several of the orders. Very rarely does it actually comply with the statute. Very rarely. So I'm not sure who it is that is falling down on the job, but it is not compliant. They're still getting their deregistration orders, but just sometimes. But they're not complying with the statute. The court, on a hearing, they may deny without a hearing. They see the motion and they go, don't care, goes over here, deny. Otherwise, they do have to hold a hearing. The prosecutor is the only person who's going to get notice about this hearing. Therefore, while I do not care if a prosecutor fights this or not, prosecutors do need to know you're the only chance of anyone putting a no to this. There are, as was discussed previously, there are actually lots of grounds. One, they're not entitled legally. There was an incident in Harris County, I believe it was, where because the individual was not honest, let's go with that, and they did not, the information of all of their prior convictions had never been produced to DPS. Therefore, their criminal history evaluation, it showed one conviction. They had two. It was by pure happenstance, namely the defense attorney told me, that I found out that they had a second conviction. This was after the certified report had already gone out. Well, that person is legally not entitled. I made a phone call to the Harris County DA's office and I said, just so you know, this is coming across, here are what the issues are. And I do not know the outcome of that case, but the prosecutors are the only ones who can fight it. All costs are to be borne by the offender. Court costs, everything. If the motion is granted, the offender's duty to register ends on the date of the court order or the date they pay all costs. Now, we collect our costs up front. You have to give us our costs when you apply. My guess is that all of the deregistration specialists, that you have to pay them before they will do the deregistration evaluation. I am also guessing that, well, courts like their money, so you have to pay the court costs up front as well. Early termination does not apply to an individual required to register as a condition of community supervision. So it does have to be a reportable offense, and it does have to be on DPS's list. This is what our application looks like. I have no idea how well y'all can see that. I can barely see it at all, but this at least gives you an idea of what it looks like. This is a new application. The old application requested some information that cannot be used in any way, shape, or form. It's asking such as, did you complete sex offender treatment? Well, the statute does not say you have to complete sex offender treatment. It doesn't say you have to ever had sex offender treatment, nothing else. Therefore, there's no reason to ask for that type of information. Letters saying, gee, this guy is a wonderful person, all of these other things. Again, the statute is clear. You may be the best person ever, but I have a job to do, and that is to follow the law. And if the law says yes, then the answer is yes. If the law says no, then the answer is no. So, an offender files with us. It's a $50 cashier's check or a money order. Again, that has to be paid up front. At that point in time, you also need to have the order of conviction, deferred adjudication. The reason for that is no matter what you were charged with, it's what you were convicted of that matters. And I'm using conviction here, obviously, reasonably loosely. So if you were originally charged with aggravated sexual assault of a child, but what you actually got was indecency with a child by exposure, that's what I'm going to go with. Because, well, I have to. And again, as discussed earlier, we have to have fingerprint-based criminal histories. It is the only way to make sure that we actually have the correct person. I know a lot of people, this goes to offenders and attorneys, they like to use public data. Public data has some immense problems. They are required to destroy their old copies of the criminal history database, and they don't always do it. They're using something well out of date. Who knows what's going to go on? Like I said before, criminal history has its problems, but it is the best source that we have. I will then rephrase that. My paralegal will then take the very first initial cut. She will look at all of the no's, all of the maybes, and the yeses immediately come to me. Yes, sir. If it's a single count, it's a single count. It's one. Convicted on both? Then yes, that would be 2 counts. That is correct. Now what's interesting about that is under federal law, it used to be the way they looked at it from the AG's perspective, and I'm talking about, how long ago did I leave? Almost 15 years ago. So some of my law has changed, I'm sure. If you had 1,000 images, that was 1,000 counts. But there was a court case that said, no, you convicted them on only 1 count, no matter how many images there were, that's a single count. So presumably, if you're going to do multiple counts, then I'm going to treat it as multiple convictions. If anyone ever shows me that I am wrong, I am more than happy to change, because like I said, my purpose here is to follow the law. I never want to intentionally or even unintentionally not follow it. Does that answer your question? So again, first question, is there a single reportable conviction? Second question, is it from a Texas court? No one from out of state, no feds, no UCMJ, they do not count. Now what gets tricky with this is we obviously have federal courts and we have UCMJ courts in the state of Texas. Doesn't count. It has to be a Texas district court. And the reason I'm specifically saying district court is everything that's going to be eligible for us is a felony. And the next question is does the reportable conviction require registration under Texas law for longer than is what required under federal law? Because as Janine pointed out, those are the standards. This is the code provision that Janine mentioned, and here's what it looks like, straight from the Secretary of State's website. You'll notice it has an attached graphic. You'll also notice that this was just passed, well, partially my fault because I pointed out to Janine that it said it's a rule, and I'm sorry about that because I created all kinds of work for her. But it is very recent, but the advantage is it makes everything clear. It's not up for debate. It is what it is. After that, it's going to have to be appealed as being an incorrect rule, or you're going to have to sue that it's wrong. Here's what that attached graphic looked like. Notice how nice and easy this is, and there's going to be something that makes it even easier. All of the offenses are tiered, and all you have to do is know, just from the rule, there's, like I said, there's a document coming up that's going to make it even easier. Just from the rule, is it a lifetime or is it post-10? If it's lifetime and you're a tier 1 or a tier 2, you're eligible for deregistration. If you're post-10, you're never going to be eligible unless you have no duty to register at all. And yes, there are offenses that there's no duty to register at all. And here's where it gets a lot easier. This is actually the full copy of the current full copy of the front page of the Texas Public Sex Offender website. And I do not know if it's visible up there, but the second star on the right coming down, it says additional materials. That is where Janine has put this very handy list that looks just like this. And if you can't figure out that red means stop and green means go, well, we can have a discussion about that. But everything is very easy. It is very clear. This is why my paralegal, she used to have to come to me all the time asking questions because of the old list. She hardly ever asks any questions anymore. This is so incredibly easy. Even an attorney can figure it out. And I'm going to tell y'all, just so that it helps me remember that I actually need to do this, there's actually one offense that I would like to discuss with Janine so that we can decide whether or not there actually needs to be more people added who may deregister. I've been told you, I eventually found the list. So after the application has been reviewed, one of three things is going to happen. A letter is going to go out that says it's been denied, that I need more information, or that you are approved. It is actually pretty common that we need more information, but I can also tell you, and this is no small part because a lot of the people who apply are lay people, the vast majority, I would say, probably, and this is purely just from anecdotal, I would say probably 60% of all applications are denied. They do not meet the legal requirements. The next biggest package is we need more information. Just what we needed is not in what was provided. Very few people are approved on a percentage basis. If you're approved, that's when you go obtain your individual risk assessment from a deregistration specialist. A copy of that evaluation is sent to the council. The council will receive it, and they will look at it to determine if certain objective criteria have been met in that evaluation. Did you ask how you feel about your mother? Whatever it is, it's very specific, and again, this is where the science comes in, and, well, I went to law school. After it has been approved, it then comes directly to me, and I will certify the evaluation, assuming the council has approved it for certification. And that's what the stamp looks like. It's going to go on the evaluation itself. I'm going to sign it, I'm going to date it, and then I'm going to send it to you or the offender. At that point, we're done. The council has nothing further that it can do. Everything after that is up to y'all filing it in court, fighting it in court, waiving your right to fight it in court, or if there are any judges granting it or denying it. But we no longer have any interest in it whatsoever. There are a lot of common issues, but the two big ones are verification of age of the victim and actual consent. Verification of age, if you remembered on the application, it does request what the age of the victim is, but I can tell you, unless it is going to give me grounds to give it an automatic no, I'm going to take the age of the victim with a grain of salt. First of all, I have had people that unquestionably have lied about it because when they put the age on there, it wasn't even close. Like, really, more than 10 years difference between what their age was. Sometimes people put it what the age of the victim is right now, and they got convicted 20 years ago. Sometimes they have people who they put the age of the victim at the time they were convicted, not at the time of the incident. And I have to know when it is at the time of the incident. I actually will take lots of things as proof of the age of the victim. Everybody always says, but you'll only take the offense report. No, I promise I will take other things. I will take pretty much anything that I can do that gives me a colorable claim that it actually is the appropriate age that we can grant it, and it's reasonably good. I'm going to take it. But I just can't just assume the offender is going to be completely honest and accurate. Of course, trying to obtain offense reports and other pieces of the case can be a little difficult because the case has already been closed. These are juveniles and sex offenses, and therefore all of this information is non-releasable. This is what one attorney did. It's the smartest thing I've seen on the job yet. She made a motion to reopen the case just to obtain the information. And this is the only piece of information I'm actually going to show from one of our cases. Our cases actually are confidential. We are not allowed to discuss them, but obviously this is a public record. And it was granted. So if I ever say I need more information and you can't figure out how to do it, give it a shot. What's the worst thing that could happen? Worst thing is the judge is going to say no. So, I don't know if y'all can read this or not, but now's where the fun part becomes. We're going to look at this test record and see, actually, you know what? Let's use the better version. Thank you to Janine for making this public so I could download it so everyone could look at it. And as you can tell, the Hamburglar has been bad. And the reason I'm not using an actual case is, again, all of our information is confidential. I cannot share it with you. Even though a lot of them are public records, I am showing you information of who has and who has not applied. The only reason I felt okay with it with the other one is, yes, it is unquestionably, this is a court document that is highly releasable. And I'm really pointing out the attorney more than I am anything else, and I mean that in a positive way. So an individual, this is a test record that DPS has in their sex offender registration bureau. I will sometimes say unit because I'm old. And this is, none of the information here is real, and some of this information is going to be contradictory. But I can tell you, assuming that everything in here that you're looking at right now is accurate, I can tell just from right here this individual is not entitled for deregistration. Can anyone guess as to why? No, he's quarterly. The only way you can be quarterly, you have more than one conviction. And I will tell you, there's a lot of these things that I do. I worked with the sex offender unit, bureau for 4 years. I was the only attorney, and therefore there's a lot of the stuff that is second nature to me. I will use a lot of shortcuts like that. If I see that it's quarterly, it's going to be an automatic denial. Now, if I'm ever wrong, let me know. I have zero problem with being told I'm wrong as long as you can show why I'm wrong. And there's a reason I'm going down, I promise. Attempt to commit sexual assault of a child. Obviously, there's one of the other inconsistencies. He's quarterly. Attempt is always post 10. Based on this information, is he or is he not eligible? Anyone? Well, without looking at the age, just let's start with attempt to commit sexual assault of a child. Correct. He is not eligible, and the reason for that is under Texas law, he is post 10. Under federal law, he's lifetime. Federal law does not make a distinction between attempts and actual commissions of the offense. Texas does. That is probably one of the other reasons why we're never going to be SORNA compliant. But, as someone rightly pointed out, the victim's age is 25. So that will give you an automatic yes or no. Is the individual eligible for early deregistration? Anyone? If you have an adult, if you have an adult victim, they're automatically not eligible for deregistration. Because at all times, if you have an adult victim and it's sexual assault, this is a crime of violence. All crimes of violence are lifetime registration in the state of Texas. They're also going to be lifetime registration under federal law. And one last thing I wanted to point out is you saw the Hamburglar, you see the rest of these pictures that are here. There's Sideshow Bob. We'll not discuss why that's with a sex offender, although I'm sure Janine loves it, being the Aggie, and a koala and a puppy. My point here is someone at DPS put these on here. They obviously have a sense of humor. They're people. All of us, both sides of the aisle, have to remember everyone here is a human. No matter what they've done, no matter how difficult they're being getting information from DPS, me returning a phone call, whatever it is, everyone here is a human being. And it would be best if we tried to treat each other well. Sometimes some things can get contentious. There was an incident in my office last week or this week, I actually don't remember anymore, and it was an offender. It was not an attorney, admittedly. And attorneys can be difficult, but at least you and I speak the same language. This offender was being belligerent, and one of the paralegals could hear me discussing things with the offender. I wasn't yelling, I promise. Our office just isn't that big. But I had to say the same thing over and over and over again, but the key to it is I didn't ever yell, because all of us have to remember that we're people. Any questions? Yes, sir. The question would be, why was it denied? The reason I ask is if you think I'm wrong, call me. That's all it takes. Just call me. I'm not going to tell you how to practice law. And I'm certainly not going to help you get a judge to say I'm wrong. But no, I mean that seriously. And this has happened before where something got missed. It was a denial letter that went out. The attorney contacted me, and he says, you missed this page. And I went, what page? And he said, that one right there. And I went, oh, you're right. Here's your letter for approval. It's that simple. Everyone thinks that DPS, and probably me because I worked at DPS for so long, that we're here to deny people. I'm here to follow the law. Nothing is ever personal with me because I don't know these people. But I do have a job to do, and therefore I'm going to do it to the best of my ability, whether that's yes or no. Any other questions? Yes, sir. Uh, I do not have any knowledge. Like I said, we have the $50 fee that's up front. You have the deregistration evaluation. Dr. Ferrara will be here, as will Dr. Pierce. They will be able to give you a much better idea of how much not only they charge, but what the going rate is. Of course, I'm making assumptions here. I'm assuming Dr. Ferrara is probably a little more expensive than other people, but how many people know more than he does? I mean, he's kind of one of the people in the entire, probably country, but certainly the state. Any other questions? Yes, sir. I assume you're meaning that they've gone to court, they've gotten the order's a valid order, i.e. there were legal grounds to grant it. Everything like that? Well, okay, are you talking using deregistration, or are you talking the individual has completed their requirements legally, such as a post-tenure? Which one are you referring to? Okay, completed their terms legally. At that point, as Janine had said earlier, DPS does generate information for their local law enforcement agencies that do registration, that they will get a notification Mr. Merchant has fulfilled his 10 years. At that point in time, it is up to the local law enforcement to submit the paperwork to have the individual removed from the registry. So going back to our first presentation, DPS doesn't do anything. All of their stuff is based on information that is provided by other people. Whether that is probably, I'm guessing their single biggest register is TDCJ. And then of course you're going to have Harris County, Travis County, Bexar County, Dallas County, Tarrant County, etc., etc. They're having to submit all of the information both to register and to deregister. Now, deregistration by deregistration order, that is going to go to DPS, and then DPS is going to determine whether or not this was a valid order, i.e. were there multiple convictions, etc., etc., and then they will remove the individual. I can tell you just from what actually happens is I also get a email, did this person apply? Because it is always possible that the individual does have a deregistration evaluation, but it was never submitted to the council to be certified, and that is a requirement of the statute. It is also possible that they never even got a deregistration evaluation at all. I have seen those, although that's still nothing. It's one of my favorite stories from working at DPS. We had a Texas conviction, Texas resident. He went to Oklahoma, got an Oklahoma judge to sign an order that says this individual no longer has a duty to register in Texas. So that is why we have people who are actually watching what's going on. Although that's still not my favorite story from DPS, total sidetrack, and it goes to why we have so many problems with criminal history. I saw an order, it was from the mid-'80s, if I remember correctly. We were doing some research, and the individual got a conviction for a Class C misdemeanor murder. I'm not kidding. I wish I was, but I'm not. As everyone here knows, that's not even legally possible. All I can tell you is that's what the order said, and obviously somebody desperately needed killing. Any other questions? Yes, sir. Absolutely not. That is the sole responsibility of DPS under statute. I'd pick up the phone, but that's all I'm going to do. Because I can't. The list is DPS, and I'm bound by the list. given the fact that the statute says that the list is supposed to be compiled in cooperation with the SMART office, and I do not have any knowledge any longer of anyone at the SMART office, and DPS does, I know for a fact that they have gone through that cooperation with the SMART office through their evaluation for Adam Walsh compliance, I'm going to rely on DPS. And if you ask me, the proper term after that, if anyone thinks that the list is wrong, is to sue DPS, not me. Any other questions? Sex offender monitoring, apprehension, registration, and tracking. That is, the SMART office is the federal office that deals with the Adam Walsh Act. And it has been around since 2006, I believe. Yes, ma'am. I guess, so you're saying like an old offense, a retroactive? Any individual who has a reportable offense that occurred on or after September 1st of 1970. The United States Supreme Court has dealt with this in Smith v. Doe, which is a case out of Alaska, if I remember correctly. And Janine, what's the name of the Texas Court of Criminal Appeals case? Reynolds v. State. There you go. Retroactivity is fully allowed. The reason for that is this is not a criminal offense. This is merely a civil offense. This
Smith leaves open some wiggle room if there is some kind of penalty associated with it.
correct, but there's no. This is the argument I'm about ready to make is the identical one to juveniles never get arrested. But if it walks like a duck and it talks like a duck, it's a duck. There are no penalties involved in sex offender registration, at least according to the law. There is none that I am aware of because, like I said, the Supreme Court and the Court of Criminal Appeals, the United States Supreme Court and the Court of Criminal Appeals here in Texas have both spoken on the matter. Yes, sir. But there is no question, and this is coming from my time at DPS, and I can't imagine that DPS has changed their position. That is a legal requirement for registration. You have now discovered one of the problems with sex offender registration. Well, I'm absolutely not. I'm saying that they would be required to register. They would be required to register because there's nothing in the statute that allows for any exemption for registration except juveniles and subchapter I. That is it. I'm a state employee. I'm going to say that they have a duty to register. Well, with the understanding I'm not going to fully answer you, the first question would be is when was the agreement made in context of the statute itself? So if the agreement was made right now, that could be one answer. If the agreement was made 30 years ago, that could be a different answer.
One more
yes,
question.
Sir. I didn't say there was no penalty for failure to register. I said there is no penalty for registering. Registering. That is correct. There is a penalty for that. There's a failure to comply with civil statutes. There can be all kinds, and this is a civil statute in reality.
And it's a crime.
And it's a crime.
One last question.
Yes, sir. Juveniles do have to register, but the court can exempt them from registration. So if the court exempts them, my recommendation at that point is you need to talk to DPS of exactly how they want to deal with that. I can tell you what it was 10 years ago. I would not want to tell you what it is now.
All right. Scott's going to be around for a while. We have lots of questions.
All day.
And he's here to answer questions. This is all part of our the idea of getting education. Mary, there are 2 states. In Colorado, there's a case on retroactivity of deregistration that went in favor of a defendant. There was a case also in Michigan recently, and there's some question about penalties. Municipalities that say you can't live in certain towns, like the city of Pasadena or Lake Jackson. And, those are issues that's a penalty that's associated with sex offender registration that may change Smith versus Doe. That's something that's going to be litigated. And Richard Gladden is doing some really yeoman work. And Scott Smith's doing some yeoman work on fighting registration or requirements. Thank you very much. We're on a break, and we'll come back with Scott Poggin. Sex offender registration. One of the most knowledgeable people that we have that knows something about this subject besides people at DPS or prosecutors or Matt Farrar or Aaron Pierce. So Scott Poggin is going to tell us about the procedure.
All right, what I'm going to go through, and a lot of this has been covered by other speakers, but I'm going to give kind of the 10,000-foot view on the process that you go through for the deregistration. Now, the first question that comes up is, how did this deregistration law come about? And sorry, normally being able to hear me is not ever a problem, but you know, the first question that a lot of attorneys ask me when we're discussing the deregistration program is, how did this come about? Because originally you had the sex offender registration program that was originally created, it got amended, and then when the Adam Walsh Act came out and SORNA came out, it created deregistration schemes within all the different states, and Texas adopted the deregistration scheme that we will be discussing. Now, what offenses are eligible? You've heard this quite a bit. DPS, as was talked about earlier, was by rule to determine under the Adam Walsh Act, under the Federal Sex Offender Registration Act, what offenses were tiered. There's 3 tiers: tier 1, tier 2, tier 3, and what offenses under state statute were reportable convictions that required registration longer. The registration period under Texas was longer than what the federal law required. So those are the offenses that are eligible. And you've seen the chart. It's been linked. You've gotten the websites that has it linked. There's going to be discussion about changes in the chart, which just recently got done. But the key threshold is, do you have to register longer in Texas than you do under the feds? Now, there's additional eligibility requirements for this. First one is it can only be one reportable conviction. So for the defense attorneys out there, when you're negotiating a plea, especially if there's multiple counts or multiple indictments, one of the things that you can do that can be a benefit for your client later on down the road is try to get it where the plea is going to be to a single count or a single indictment with only one count. This way your client later on down the road could possibly, especially if he's in one of those offenses such as an indecency with a child, where the age is 14 to 17, something like that, you're doing a big benefit to your client because he could possibly deregister down the road. Where if you allow him to plead to 2 counts or the like, then it's not going to allow the deregistration. Yes. I believe that if they're 1245, then they're not going to be final convictions, so it would only be a single reportable offense. So I think that's another way to handle it. For the prosecutors out there, when the defense attorney is coming trying to get this down to a single count or a single indictment, keep in mind that the defense attorney's not trying to be crazy. They're trying to do something that's going to eventually benefit their client in the future, and that's why they're asking. Now, the next thing is it has to be a Texas conviction. Now, if you look through subchapter I, it never says that it has to be, you will never see it say it has to be a Texas conviction. What it will say is you have to go to the court that you were convicted in, and we'll get into that later. But that's where it's been interpreted that it must be a Texas conviction for you to be able to deregister. Now, I think it creates some equal protection problems. For instance, I think that somebody with a child pornography conviction in federal court from one of the Texas district courts, the feds only require a 15-year registration, but since it's substantially similar, it's a lifetime registration. You would normally be eligible if you were convicted in a Texas court instead of a federal court of that one count of child pornography to be able to deregister. But because you were in the Southern District of Texas and you got convicted, you are not eligible because it's a federal conviction. Personally, I think that could be challenged under equal protection grounds because similarly situated people, in other words, people convicted of the same offense but they're just convicted in state court, are entitled to the statutory deregistration but not in the federal court. Now, if eligible, what happens next? Well, as you heard from the last speaker, there is a process that you go through. The Council on Sex Offender Treatment had to develop a risk assessment tool, and they also had to approve the sex offender treatment providers that are allowed to give this risk assessment tool. I think there's 21 of them in the state right now, but you have to go to one of those and get a risk assessment done. The applicant has to pay the costs for the risk assessment, and the assessor must provide a written report that will be certified by the Council on Sex Offender Treatment. And you must get that certified report in order to move on to the next step. Without that, you're stuck. Now the petition. It has to be filed in the court where the offender was sentenced. So whatever district court that came out of, that's the court that you go to. The petition must include a written explanation of how this offense, just like we talked about, requires registration longer in Texas than it does under the feds for the tiered system, and the certified copy of the risk assessment. I haven't come across this situation yet, but personally, I think the role with the council when you go for the certified copy of the risk assessment is to have their individual their treatment provider do the risk assessment and provide that. I think the gatekeeping function where they go through and they're checking to see if you only have one conviction, those kind of things, I think that's the duty of the court. It's only required that you get a certified copy of the risk assessment under the statute. Doesn't require that you get a certified letter from CSOST, the Council on Sex Offender Treatment, that you are eligible. Now there's a hearing. First of all, it is discretionary. The court does not have to hold the hearing. Or let me back up to the petition. You are not limited by what is required, just these two items in the petition. And I would suggest as a practice tip that you put much, much more into this petition if you're going to want to get past the next step to get to a hearing. Generally, I try to get additional risk assessments done by a private psychologist or psychiatrist. I will try to, if the person was on probation and successfully complete it, get an affidavit or statement from their probation officer, get letters of recommendation from friends, family, employers, show that they're gainfully employed, do those kind of things, because you're going to have to convince the judge to want to hold a hearing in the next step. So I would include everything in that petition that you can. And, depending on what kind of package you can put together, you might actually get some cooperation from the state in the next hearing and not as much, and have a much easier time getting the deregistration through if you put a good enough package together. Now, like we said, the court doesn't have to hold the hearing. They can deny the petition without ever holding a hearing. Now, what I like to tell my clients is if we get to the point where we have a live hearing, then that means that we're in the ball game. The court's willing to consider actually granting this, because a lot of times, if they're not inclined to do it, they're just going to dismiss it outright as soon as the petition is filed. Now, the court may not grant the petition if there is no written explanation of how the offense qualifies, and if the court determines that the reportable conviction is not longer than the federal period, or the risk assessment is there. Now, different courts will do the hearing different ways. Hopefully, if you'll have a hearing, they're going to allow the witnesses to come in, testify. You can have the people that did the risk assessment, your own expert, who either verified the risk assessment or did their own. All those witnesses that you help line up and get affidavits, those are the kind of things that I think a judge is going to want to hear. Keep in mind when you're doing these, judges are elected individuals, and they are scared somebody that they signed the order for to allow deregistration is going to become their Willie Horton. If any of you remember who that is. You know, you have to try to make it as comfortable as you can, both for the state to agree to it, because if they're agreeing, it's going to be much easier on the defense side to get this through, and you have to make it as comfortable as you can for the judge to be able to sign this. He has to feel comfortable that this isn't somebody who he's going to have to be answering questions in the future. Now the order. It can only be granted after a live hearing. You can't just submit things and then the judge say, yeah, based on the paperwork, I think this person doesn't need to deregister. The court has to give notice to the district attorney and to the person when they sign the order. And the order has immediate effect at the later of either the signing of the order, or if there's still costs out there outstanding, once those costs are finished getting paid. Now, there's a question about, with this tiering and the deregistration and the minimum requirement is 25 years. There's no requirement under the statute that you have to wait the amount of time that the federal statute requires you to wait to deregister. As a matter of fact, the statute even contemplates, if you're still on parole or probation and you have a registration requirement as part of that parole or probation, as soon as that order goes into effect, then those registration requirements under your supervision are gone. So, I mean, technically, I don't see it happening, but technically I think you could file a petition as soon as you get placed on probation for an eligible offense, and you would be eligible to deregister almost immediately. So, I mean, that's the basic overview. Anybody have any questions? Because I know that's probably going to come up. That's why I kind of cut this a little bit shorter. Well, that's the threshold. You don't get past being able to file the petition unless that's the case, that you have a state registration requirement that's longer than the feds. So it's a threshold thing. You have to meet that requirement to get through anything else, but then you have the hurdle of having to convince the judge and or the state to agree with you on this. Correct. Neil, Neil, for purposes of deregistration, you have to get that specific risk assessment that the council's approved by one of their approved treatment providers that they've approved to give that risk assessment. And and that risk assessment will get sent to the council. The council will certify it and then forward it on to the individual. Now, I think what's going to come up, and I know it hasn't been litigated, is that risk assessment will get done. The council will decide that there's something else that makes the person ineligible and doesn't certify the risk assessment. But I don't think that's what the statute says. That's for the judge to decide if you meet the requirements and sign the order. Yes.
Is there somewhere in the list
Yes, you can get the list from the council. I don't recall if it's on the website, but I believe it is. I haven't checked recently. I know it used to be there, but you can get it from the council if you're looking to try to deregister. Yes. Well, I mean, if you want to file it under seal, it would require an order by the judge sealing it. Generally, you can file it, start a new case, hit the has sensitive treatment, and that would notify the clerk that there is some information on this. Also, under a lot of local rules regarding electronic filing, the information that would be in the risk assessment would be things that would need to be redacted for public view. Yeah, well, technically in state court, the judge has to order it sealed before it's sealed. And with electronic filing required in most places, a lot of times I'll try to file things from do the electronic filing from the courthouse, walk over to the court with the order to seal, and then walk that order over to the district court. That's how I generally handled it. Yes.
If I agree as a state to the motion to deregister, we still have to have a hearing.
There's still under the statute, there still has to be a hearing. Now, that hearing could be the judge calling the case saying, state, are you opposed? No. I find that all these requirements are met, signs the order. Doesn't say what has to occur at the hearing. It just says a live hearing is required before an order is signed. Yes. Once again, I think the statute says that they just have to certify the risk assessment. I don't think they have any ability under the statute to keep you from moving forward.
I think what you'll find with the risk assessment, what Matt will tell you later, is that you get various degrees of scores. You'll get high risk, low risk, and everything in between. And because it's objective, you get the score that you get. And no.
No, they can't say they don't approve it. Now, as a practical matter, I don't know any judge that's going to approve a petition to deregister where the certified.
Where we got the defendant's Ted Bundy.
Yeah, I mean, you get good enough experts, maybe they'll ignore the council certified expert, but as a practical matter, I don't think that's going to happen very often. Yes. That's going to be an individual assessment for you as to. She asked, when you're talking about getting other risk assessments done, are there risk assessments that they find more credible than others? And that's going to be an assessment you're going to need to make based on the qualifications of the expert you get, what kind of things they're doing, those kind of things. I mean, there's no, while the council has certified these risk assessments, there's no, in the science and the literature, standardized risk assessment that says this is definitely the only way you can do this. So, you can get some very qualified experts that are going to rely solely on things such as the static 99 or the static 2002 now, the MSOST, empirical tests like that. There's going to be some that take more of a, organic approach, look at work histories, look at other factors to factor in whether they perform a risk, whether they completed sex offender treatment, how well they digested that information, how well they can explain it. So there's different factors that can come into that.
You can also get the sex offender treatment provider to write a report based upon the treatment, and that will supplement what the risk assessment has done, because you have coming from two different approaches. Speak up, please.
Yeah. The last one of these that I did, I attached to the petition the treatment provider that they went to during parole, the certified sex offender treatment provider. There's another treatment provider that we hired. I attached some of the research, the empirical research that's out there regarding recidivism rates and offenders, some of the science behind it. And I attached, like I said, letters of recommendation from employees, friends, ministers. I think there was a chief of police that even wrote a letter of recommendation in that. Whatever you can get that you think will be persuasive to the court, front loaded on that petition to hopefully get your hearing. Yes. Anything else?
And now we have a microphone.
So if the whole threshold issue is that the Texas length is longer than the federal requirements, and you file earlier than the end of the federal requirement, is it just a matter of persuading that there's something that justifies that? I mean, it seems like if it's only based on that length, and then you're going ahead, you're going earlier than that, kind of doing something that
Well, there's some judges out there that are going to say, well, if the Fed said this is the minimum amount of time that you have to register, that's what I'm going to listen to. But other judges, well, when you point out to them the statute doesn't have a minimum time that you register, you point out the fact that, in the section of the law that talks about the order, it even contemplates people on parole and on probation having the registration requirements taken out of that, then a lot of judges will say, okay, the legislature meant for this to be able to happen at any time. Has he been off of, has there been enough time from the offense? Has he done enough to prove to me that he's not going to be a risk to reoffend in the future? That's kind of the judgment you have to make and sit down with your client. But a lot of judges will listen to that. Some won't.
Any other questions? Is there any appealability if judge denies you that you give the live hearing or appealability for your time? That's what
Well, there's nothing in the statute that gives you a right to appeal. I have a feeling, having dealt with similar issues with the civil commitment of sexually violent predators, and it being found that without a statutory right to appeal, I think most appellate courts are going to tell you that they don't have jurisdiction over the appeal and pour you out. I'm not aware of anybody that tried to appeal the fact that they didn't get a hearing. You're going to have a hard time with it being totally discretionary, getting over an abuse of discretion standard in that situation.
I don't see abuse of discretion. Any appellate court in the state of Texas ever overturning a judge's decision not to grant a deregistration, because it is purely discretionary.
So under the lifetime registration scheme, if federal court,
under the federal scheme, where you have lifetime registration, there's an opportunity to file to deregister after having registered for 25 years. Does that change or give somebody convicted under Texas law the opportunity to file for deregistration if they have a lifetime registration after having registered for 25 years? Does that translate between the two or no?
Well, it gets confusing with the tiers. The only thing that the tiers do is they lay out the threshold of what offenses are eligible for deregistration. It doesn't lay out any minimum time required before you can file for it. It's only a matter of the threshold of what offenses you can deregister for. And I think originally, the Adam Walsh Act was something where a state could opt in, opt out. And when this was originally drafted, I don't think Texas had decided if it wanted to opt into the Adam Walsh Act or opt out. As the DPS attorney stated, there's only 12 states that have decided to opt in and be compliant. But I think when this was originally drafted, they were trying to track the Adam Walsh Act language and those kind of things.
I have a question. If you go to a live hearing and you lose, do you have the right to petition again later for deregistration?
That's a great point. There's nothing in the statute that limits you. What I have done on a couple of occasions where the judge has denied the deregistration is I asked the judge, what would you like to see from my client? What would you like to see him do to make you comfortable to do it? And I made sure that my client followed through on doing what the judge wanted to see him do. So just because you're turned down doesn't mean you can't come back later on.
So if you're on the federal and Texas state list as a lifetime registrant, but the client has successfully fulfilled everything they need to do for over 25 years of registration, there's a chance that you could be deregistered?
If they're both lifetime registrations, then it's not going to meet the threshold requirement because the Texas requirement is not longer than the state requirement.
Okay, thank you.
Any other questions? All right, we start at 12:30 with Matt Farrar. Is it Matt or Aaron? Aaron first? Matt. Matt Farrar is up at 12:30. See you then.